Now, President Uhuru Kenyatta has been on the crossroads with the judiciary, which has dealt a major blow in several rulings. The latest being a declaration by the High Court that the appointment of Nairobi Metropolitan Services Director General Mohammed Badi was illegal and in contravention of the Constitution. But what next after the ruling? Will Badi avoid cabinet meetings? KTN's Daniel Karuki picks up from there.
Article 152 of the 2010 Constitution, Part 3 of the Executive, highlights that a cabinet shall consist of the President, the Deputy President, the Attorney General, and not fewer than 14 and not more than 22 cabinet secretaries. But President Uhuru Kenyatta, in an Executive Order number 3 of 2020, and after taking an oath of secrecy at State House September 2020, allowed NMS Director Major General Mohammed Badi into the same cabinet. This had drawn criticism from various corners, with concerns over protocol and the chain of command, as Badi was to sit in a cabinet where his boss, the Chief of Defense Forces, did not sit.
Wanalia kwa nini jeshi hata mnaenda mpaka kotini kusema, kwani mnafikiria wanajeshi sio wa Kenya? Mkono ambao unabeba bunduki una uwezo pia wa kubeba jembe.
But the ruling by the High Court that termed Badi's appointment as illegal and that the appointment to also attend cabinet meetings was not approved by the National Assembly has left more questions than answers. Critics have questioned the mode in which the order will be implemented and how the same will ensure that Badi does not sit in the next cabinet meetings.
If the Attorney General has been giving the President proper advice and he doesn't take it, then the Attorney General should resign. It's either way. It's either he is receiving bad advice, legal advice, then he should fire the Attorney General.
President Kenyatta has severally been accused of disobeying court orders in more than one scenario. He was accused of transferring the Kenya Meat Commission (KMC) from the Ministry of Agriculture to the Ministry of Defense against a court order which had declared the action unconstitutional in violation of Article 10 of the Constitution, and that there were no public participation. The court had also ordered the president to appoint 41 judges to take up positions in the judiciary. The president appointed only 34 of the judges.
But it cannot be that a president who swore by the Bible before God and the people of Kenya to protect and uphold the Constitution is the same man who is defiling the Constitution.
It greatly undermines the rule of law for the government to act in defiance of court orders. And this pattern puts a great risk to our constitutional democracy because it risks the contagion of lawlessness.
The judiciary has indeed tested our constitutional limits. While I stand by the rule of law, and I will always obey the decisions of the courts, I am also compelled by my position to heed the sovereign and supreme voice of the people of Kenya.
President Kenyatta has been at loggerheads with the judiciary, and the latest ruling is one that every eye will be keen to watch if it is implemented and if Badi will continue to attend the meetings despite the court ruling. Daniel Karuki, KTN News.
And back to the politics of the day. 10 months